Good morning, Your Honor. I'm sorry, they switched us over, so I did not hear the last thing that you said, Judge Northcutt. I can't hear you.
Yeah, I'm muted. Sorry. I said, if you want to reserve some of your rebuttal, time for rebuttal, let me know.
Yeah, 5 minutes, please.
That's good. That's good. I seem to see you and Miss Jones a lot together lately.
It's okay, because that's what happens when you deal with the Department of Highway Safety and Motor Vehicles a lot.
We're happy to have you both. Okay, you're up, Mr. Isaac.
Thank you. Good morning, Your Honors. On behalf of David Coffey, the petitioner, my name is Alam Michael Isaac. This is an action that originally began as an administrative hearing for a driver license suspension for allegedly refusing a breath test. That was the result of an arrest for DUI back in March of 2021. The court, we had a hearing before the Department of Highway Safety and Motor Vehicles. We took first-tier certiorari to the 13th Circuit, who entered an order. So we're now before this honorable court in second-tier certiorari. I'll start off by acknowledging that I understand the hill we have to climb in second tier. Applying the correct law incorrectly will not get my client the relief that he needs. However, there is a very large body of law that represents a second tier relief is appropriate when the circuit court in its appellate capacity in first tier did not apply the correct law. And that is the point that I believe I've made and I've argued in both my petition and my reply. The law that should have been applied in this case should have been this court's decision in Davidson, as well as the Florida Supreme Court case in Dobrin. Just to start very briefly, there's obviously two ways that a traffic stop can be valid. It's either a traffic infraction stop or a non-traffic infraction stop. I argued both at the hearing level as well as in the circuit court. When the 13th Circuit entered its order, it completely ignored any discussion with regard to whether the traffic stop in this case. Yes, Judge Black. I can't hear you, sir.
You're muted, Judge Black. You seem to be anyway.
I can't hear him either.
It's not showing muted on this. I think you're having a technical. Now you're muted. Okay. Judge Black.
Can you hear me, Judge Northcutt?
Can you hear us, Judge Black? I've stopped your clock, Mr. Isaac, by the way. So
Thank you, Judge.
I sped it up. No, I'm teasing.
That's a good thing. I don't see Judge Black moving, I don't think.
Yeah, he's kind
Huh?
of now he's there. Oh,
There we go, somebody.
he's got Rita with him. He's got our crack IT staff with him.
Yeah. I've only done this once before, Judge Northcutt.
It's like it's really amazing how many of these we've done over the last
I know, yeah.
2.5 years, and how seldom it occurs compared to the number of sessions we've had. But
It does happen.
this is
The one I did work okay. It's the first time I've done it. I've done a bunch of team stuff, hearings and things like that, but oral arguments I only done one.
is that right?
By Zoom, yeah.
Yeah,
I'm old school. I like being there.
it's gone quite smoothly overall. And I will say, when we started, our marshal's office put us through drill after drill after drill, just so that we would.
That's why I came to the courthouse here. I got the IT guys. I couldn't have done this at home.
Yeah. Or where are you?
I'm in the courthouse in Brevard County.
Okay.
I'm in my son's court, hearing room.
That's all right. That's cool.
Yeah, his wife's a county judge. We got a lot of Jacobus judges.
I guess so. I'm resisting making, well, I'm not, I guess I'm not trying to make a crack about how Judge Black's mootness could have come in handy at other times.
I notice, I like it when the judge can mute the people.
So the Jacobuses are like the Moody's over here. Everybody becomes.
Right, because Ashley and then Jim.
Judge Northcutt,
Yes.
Yeah.
are we back now?
I can speak up, Mr. Judge Black.
No, I can't hear Judge Northcutt.
I should select speakers, go to chair. And choose.
Judge Northcutt,
Yes. Can you hear me?
I choose speakers.
Judge Northcutt.
Yes.
Perfect. I think we got you now.
Thank
You not need to-
Thank
Now if
you.
I can get my head in the picture.
Yeah, we're gonna
I'll
adjust
say.
that. Thanks, everybody, for the patience.
Thanks, Rita.
Okay.
Come to the rescue once again.
Okay, we all
With
set?
everyone, so, okay.
Now,
All
if I want to mute, do I just hit mute?
Yes, you still, yes, sir.
These
Hit that mute
are
button.
still the controls. Okay.
Yes, sir.
All right, I think we're rolling.
Okay, so do we want to, we weren't very far into the argument, so why don't we just start over? Do you remember the question you were going to ask Judge Black?
I was going to ask Mr. Isaac about the criteria for a stop because he draws a distinction in his brief between the traffic infraction stop and what he calls a reasonable suspicion stop. But I don't see that in the cases myself. I saw the standard from Dobrin doesn't talk about, it does talk about certain terms, but it doesn't talk about, it doesn't break the stops into a clean dichotomy as you've expressed in your brief. So I'd like to know a little bit about where you come up with that. Does that make sense?
Well, actually, thank you very much for that question. So when you think about the Fourth Amendment, you see cases that talk about traffic infraction stops. And then you have those cases that started with the Bailey case way back when and it evolved with DeShong and Carrillo, where the driving pattern did not rise.
The main
driving
case
pattern-
now is that Dobrin case from the Supreme Court, right?
Yeah. So the quote from Dobrin, let me get to.
Well, let me give you my quote from Dobrin first. The correct test to be applied is whether the particular officer who initiated the traffic stop had an objectively reasonable basis for making the stop. And then our court adopted that in the more recent Boston case. So it looks to me like I didn't see anywhere in the case law where this split is expressed that you're talking about.
Okay, so I'm reading from
The court
Dobrin.
just talks about the reasonableness test or the objective test.
So in the quote, and I put it in my my petition. This is the quote from the Dobrin case. The only record evidence from which to make this determination was the arrest report that the officer filed as a result of the traffic stop. From this limited evidence, the circuit court concluded: 1, the record did not competently or substantially support the stop of Dobrin's vehicle on the basis of the failure to maintain a single lane, which is a traffic infraction, because the facts contained in the arrest report did not state any evidence that Dobrin went beyond a single lane. 2, it talks about speeding and it doesn't indicate that there's any evidence of speed. 3, the record did not competently or substantially support the officer's stop of Dobrin's vehicle to determine whether Dobrin was ill, tired, or driving under the influence. That's the reasonable suspicion stop, because the arrest report did not indicate that the reason for the stop was that the officer thought Dobrin was impaired. And when you look at this court's cases in both the Crooks case and Davidson, Crooks is a traffic infraction. It's not a reasonable suspicion case. It's a traffic infraction case. And this court found that the Crooks did not commit a traffic infraction because there was no evidence suggested that he created a safety concern when he traveled outside of his lane.
That distinction isn't found in Crooks. This is the distinctions that you are extrapolating from your reading of the cases, correct?
Well,
You don't find that reasonable suspicion versus traffic violation anywhere in the case itself.
well, with all due respect, Judge, I think that when the court may not use that particular vernacular, but that's exactly what the courts are talking about. You have two types of traffic stops, and this court actually in Davidson focused on that, because the Davidson makes the same argument that Crooks make. It says, hey, I didn't cause any concern for safety or affect traffic. And then this court came back in Davidson and said, hold on. Unlike in Crooks, in Davidson, the officer specifically said nobody who is not impaired would drive in this fashion. So this court specifically focused on the difference between a traffic infraction stop in Crooks and a reasonable suspicion stop in Davidson, because that added language that was there that justified the alternative theory. And this court has actually gone through a dual analysis in the Peterson case from this court. I don't cite to it in my materials. I don't have the citation handy to me. But the second DCA in the Peterson case analyzed it from both a traffic infraction theory as well as a reasonable suspicion theory, and found that it didn't meet either one of those criteria. So with all due respect, Judge, I do believe that while the court may not get into the vernacular of that I use, that you have a traffic infraction stop and a non-traffic infraction stop, the case law is very clear that there are two distinct theories.
Well, our most recent statement on the issue is found in the Boston case. Are you familiar with that case?
I am very familiar with Boston.
And reading from the Boston case, it says, an examination of the validity of a traffic stop under the Fourth Amendment requires courts to determine whether the stop was reasonable, citing Dobrin. Thus, we must assess whether the particular officer who initiated the stop had an objectively reasonable basis for making the stop. In applying the objective test, generally the only determination to be made is whether probable cause existed for the stop. Going a little bit further, the constitutional validity of the traffic stop depends on purely objective criteria. The objective test asks only whether any probable cause for the stop existed, making the subjective knowledge, motivation, or intention wholly irrelevant. I mean, it doesn't draw any distinction between traffic versus non-traffic. It just cites the Dobrin case and says, is there a reasonable basis for this stop? That's what we said in Boston.
Well, Judge, Dobrin is a reflection of the Florida Supreme Court's case in Holland. Holland adopted the Wren standard, which was the U.S. Supreme Court case in 1996. Wren is a traffic infraction stop. It is not a reasonable suspicion stop. Reasonable suspicion stops are still controlled by Terry versus Ohio.
I don't see that distinction drawn anywhere in the cases. I'm going straight from the Supreme Court's lips from Dobrin as interpreted by us in Boston.
Well, but Boston is a traffic infraction case.
So why if that was a distinction that we believed in, why didn't we say something about it in Boston?
There's no reason to address a reasonable suspicion analysis in a traffic infraction case. If you look at the more recent case of Peterson, the court invalidated the stop. The trial court upheld the stop, denied the motion to suppress, and this court invalidated the stop by conducting a traffic infraction analysis. But the court went on to say, had there been additional evidence in the record, then it would have justified a non-traffic infraction theory. It was actually dicta. The court didn't have to go to a non-traffic infraction analysis, but at the end of the day, that it actually did it. But even Peterson, it's a traffic infraction case, and I think that this is why we have some bit of confusion. I didn't get into it in this particular case, but in previous petitions, I've identified that there's some confusion throughout the appellate courts, because there seems to be mixing and matching of standards. Sometimes the courts talk strictly in terms of reasonable suspicion, and other times they're talking in terms of probable cause. And the reality, this confusion is existing because we actually need a case that gets into the vernacular. You have two theories. You have a traffic infraction theory and you have a reasonable suspicion theory. In those instances, when the driving pattern does not rise to a level of a traffic infraction, but the driving pattern is sufficiently atypical that it would reasonably suggest to an officer that this driver is ill-tired and impaired, after that officer exercises reasonable caution against misinterpretation. And there are numerous cases that talk about that sort of analysis. So
Well, turning to the order itself that Judge Huey entered, he writes, it simply requires, Dobrin does not require law enforcement to articulate a suspicion that the driver was ill, tired, or impaired to effect a lawful traffic stop in the absence of an infraction, citing Dobrin. It simply requires that objective evidence support the articulated basis for a stop. So if he has correctly cited Dobrin and correctly applied Dobrin, then there would be no second-tier cert relief, correct?
that would be correct, but I don't believe he is. I don't believe he's correctly analyzed Dobrin, and his analysis of Dobrin is in conflict with this court's ruling in Davidson. This court specifically distinguished.
His interpretation is exactly the same thing we said in Boston. Exactly the same.
Well, citing to the objective standard is not enough. It's the way that the court analyzes the case. In this particular case, like in Boston, you may have had the possibility of a traffic infraction, but the circuit court didn't analyze it under a traffic infraction stop. It simply analyzed it under reasonable suspicion stop. And when you analyze it under reasonable suspicion, you have to also take into consideration the Davidson decision. And in Davidson, this court specifically distinguished the differences between Crooks, which is traffic infraction, and why Davidson met the reasonable suspicion standard. And to that extent, the Boston court didn't have to go there because it wasn't a reasonable suspicion stop. They didn't analyze it under reasonable suspicion because that wasn't the reason for the stop. It was strictly a traffic infraction. I think the court, Your Honor, is imposing too great a onus on the court to say if the lower court in Boston didn't argue reasonable suspicion, they just argued traffic infraction, then we should have addressed that argument anyways. And I think that puts too heavy a burden on the court. This court didn't address Boston from the point of view of a reasonable suspicion case because Boston was a traffic infraction stop. But that was not the case in Davidson. Davidson is the law, Dobrin is the law, and the way the circuit court analyzed Dobrin, it's in conflict with the way that it should have been. It's in conflict with Davidson. Think about it in these terms. If all you need is an atypical driving pattern, and you don't need a statement, as this court articulated in Davidson, why was the traffic stop invalid in Crooks? Crooks had an atypical driving pattern. Crooks is driving outside of his lane, but yet it was an invalid traffic stop because there was no statement in the record, such as what the Supreme Court talks about in Dobrin, or as this court talked about in Davidson, that, oh, because the driving pattern is atypical, Crooks drove outside his lane, it justifies objectively a valid traffic stop. That was not this court's decision. This court didn't even address a reasonable suspicion theory in Crooks because it wasn't argued. That's why Boston doesn't apply. That's why I make the comment in Peterson. Peterson is a traffic infraction stop too. So when this court addressed a reasonable suspicion analysis, it was dicta. There was no reason to go there. The court went there, but there was no reason to go there. But Davidson is right on point. They argued a traffic infraction stop in Davidson, and this court said, wait a minute. It may not be a traffic infraction. It may not rise to a level of traffic infraction, but we can justify the stop under reasonable suspicion because this alternative theory is there, and that alternative theory existed in Davidson because the officer said those magic words. He articulated some basis for why he believed that Davidson was not driving as an unimpaired driver. And I think the quote is, unimpaired drivers don't drive like this. And the court found that distinction. So with all due respect, Judge, I think that a correct analysis of a very large body of law demonstrates that there are two very distinct theories. There are traffic infraction stops and non-traffic infraction stops. And those non-traffic infraction stops are those situations where the driving pattern does not rise to a level of an actual violation, but the driving pattern is sufficiently atypical that it justifies a stop under the welfare check theory, the ill-tired impaired theory, the reasonable suspicion theory. Those are all that's the vernacular in the county court, and they're all talking about the same stops. Terry versus Ohio.
Mr. Isaac, you're getting into your rebuttal time now, so use your minutes as you wish.
That's fine. I'll rest on this and come back in my reply.
Okay.
Thank you, Judge.
Ms. Jones, you're up.
Thank you, panel members. May it please the court, Alana J. Jones representing the department. Panel members, the issue in this case is whether the circuit court applied the correct law. And if there's a finding that the circuit court did not apply the correct law, it must be found that there was a violation of a clearly established law resulting in a miscarriage of justice. That's the standard that we're looking at. We don't have a due process argument here. That's the standard. And in this case, we did not have a miscarriage of justice or an application of the incorrect law. The circuit court properly applied the correct law. First of all,
Are there two ways that the officer could have stopped Mr. Coffey? Would be the reasonable suspicion or for the traffic violation? I mean, is that correct? In other words, that's two ways that an officer can make a stop, a legal stop?
There can be a stop, Your Honor, based on a traffic violation or reasonable suspicion.
So in this case, do you think there was probable cause for a traffic stop?
And this was their probable cause for a traffic stop. Well, Your Honor, there was no indication that there was a traffic violation, given that he was weaving within his lane. So in this case,
so he couldn't leave, or well, he didn't have probable cause for a traffic violation, correct?
for example, exactly. For example, crossing into another lane. He was weaving within his lane for
He could think that Mr. Coffey might have been sick or impaired in some manner, and he could have had a reasonable suspicion that there was something wrong with Mr. Coffey, correct? And stopping on that basis?
He absolutely could have had a reasonable suspicion based on the objective facts that he observed.
Right.
He observed the weaving within his lane for several blocks. So
that would get us to the other kind of a stop, a reasonable suspicion stop, correct? I guess.
So this case, yes, there was reasonable suspicion based on those objective facts, Your Honor.
But he didn't say that, did he? He didn't say he thought, look, I think there's something wrong with this guy. He didn't put that in his report at all, did he?
Right.
To me, it's just like Dover.
He did not.
The Fifth District Court of Appeal, originally, they affirmed the stop. Judge Harris and Judge Peterson, Judge Griffin evidently dissented, but the Supreme Court seemed to say that you got to articulate it in some manner in your report if that's what's going to be the evidence of the stop.
Well, I'm sorry.
Go ahead. So it seems like it's fact driven. It depends on, Judge Black was indicating there's no distinction in the law. And I think, as I understand it, the distinction comes up depending on the facts of the stop. It seems to me he needed to articulate a little bit more in his report for it to stand. I'm not sure that the circuit court did apply Dover in the proper manner, in my view.
Well, actually, Your Honor,
my point really is not whether or not the lower court got it right. My point is whether or not since we're on second tier cert, did they apply the correct law?
You're correct. I understand that. I understand.
And I could question whether or not they reached the right result based on the objective facts of the case. It's questionable.
I see what you're saying.
And Your Honor,
Did you address that, Ms. Jones? Address the distinction between the second tier cert criteria.
absolutely. Second tier cert is whether or not the circuit court or the court below applied the correct law. And it can't be merely that the correct law was applied incorrectly or even a mere error. There has to be an error that rose to the level of a violation of a clearly established principle of law which results in a miscarriage of justice. And that did not happen in this case. And as far as Dobrin is concerned, Dobrin, as was stated earlier, applied the objective test to the facts. They enunciated adopting Wren, the US Supreme Court case. They adopted the objective test, the correct test to apply, whether a particular officer who initiated a traffic stop is whether there is an objectively reasonable basis for making the stop. So the reasonable basis standard was adopted by Dobrin. And so there wasn't a requirement in that case that there be a statement by the officer that, oh, I thought he was ill, tired, or impaired. You look at the objective facts in the case, the fact that this person was weaving within his lane and weaving for several blocks, those objective facts. And then also you could look at the time of day and all the surrounding circumstances early in the morning. The objective facts presented reasonable suspicion for this stop to take place. And it's important to note, we don't rely on law enforcement officers to give us legal conclusions. Legal conclusions are for the court to decide. That's what the case law supports. And you see the principle in Dobrin, the objective test, being applied in other cases, such as Ivory v. State, where it says the motivations of law enforcement are irrelevant in determining reasonable suspicion. Also in Heard, how the driving pattern itself created reasonable suspicion. These cases are right on par with Dobrin, which applies the objective test. Now, as far as these two different standards, a reasonable suspicion, I'm sorry.
Just real quick. I don't see where he said he was weaving back and forth for miles. It just said he was on West Kennedy Boulevard near South Bill Avenue and was weaving back and forth, period.
Well, I believe there is documentation in the record, Your Honor, that he was weaving back and forth for several blocks. And
it doesn't seem to be in the, I'm looking at the statement evidently the officer made in his report that the hearing officer listened to. That's what it looks like. Maybe I'm missing something else.
Mm-hmm. And I don't have
there's in addition to the probable cause statement, there's a narrative where I think the part about the several blocks is in the actual narrative by the officer, as I recall.
Yeah, often there is an arrest report or probable cause statement and an incident report, which gives that detail.
I know that in the narrative is where the officer talks about the wheels touching the lane markers.
Okay, all right. Go ahead.
Yeah. Okay. Thank you, Your Honor. And with regard to the difference between a traffic violation stop and a reasonable suspicion stop, as the court has pointed out earlier, in the cases, there is no distinction between different standards being mandated for a traffic violation stop or a reasonable suspicion stop. The Supreme Court in Dobrin simply stated that the test to determine whether a stop is appropriate or valid is the objective test. And that's
they receded from what used to be the reasonable officer test or something like that. What a reasonable officer would say.
That's correct.
It's very subjective.
That's correct. So they did away with the subjective standard. That's what Dobrin was addressing. That was the issue in Dobrin. What is the correct standard to determine whether a stop by law enforcement is valid? So we have this objective standard, which was applied by the judge in this case, in the circuit court. And there was no violation of a clearly established principle of law resulting in a miscarriage of justice. And also before I get to the distinctions again, I wanted to point out that there was no conflict or there was no misreading of Dobrin in reference to the State v. Davidson case. Now, counsel points out that in State v. Davidson, and the court did point out in that case, that the officer testified that he pulled over the defendant because his driving pattern was characteristic of that of an impaired driver. And it's true, he did state that. But nowhere in Davidson was there enunciated a requirement that that statement has to be made in order for the stop to be supported by reasonable suspicion. They did not state that. Of course, if he testifies to it, of course it's going to be considered because it's relevant. However, it did not mean if that statement wasn't present that there would not have been reasonable suspicion. There was no requirement, no magic words were required in that case or any of the other cases that deal with the objective standard. The objective standard is what is required in this case. And that's what the circuit court applied. And therefore, there is no violation or application of an incorrect law. Also, you have the same issue in Maggard. The Maggard was a first DCA case. Now, petitioner argues that Maggard was wrongly decided, but that's merely because the binding case law, which is binding on which they adopted the Wren standard, and they specifically cited Wren and Maggard. That court stated that the objective standard is what applies as is consistent with Wren. No, simply, just because something goes against your argument doesn't mean it doesn't apply. That court adopted the Wren standard, which is an objective standard. The first DCA stated that the absence in an arrest report that the law enforcement officer initiated a stop for suspicion of impairment, the absence of such a statement does not negate the objective existence of probable cause. That's consistent with Wren. That's consistent with Dobrin, which adopted Wren, and it's consistent with the other cases that are cited in our response. The circuit court applied the correct standard in this case. Basically, concerning these different standards, what petitioner is arguing, petitioner is basically arguing for an expansion of Dobrin. That's what they're arguing. However, expansion of Dobrin is not appropriate on second tier review. The question again, was there a violation of a clearly established principle of law? Now, maybe petitioner would like there to be two different analyses for these two different stops. However, the courts have made no such dichotomy, nor have they mandated that a different analysis should be made for a reasonable suspicion stop and a stop based on a traffic violation. To do so would be to expand Dobrin, and that's not appropriate on second tier review. Again, the objective standard was enunciated by Dobrin. That was applied by the circuit court, and the circuit court complied with the law. And therefore, we believe, based on the arguments made in our today, based on the arguments made in our response and the record, that the petition for writ of certiorari on second tier should be dismissed.
Thank you, Ms. Jones. Mr. Isaac, you're up to rebut.
I have 5 minutes, Judge. Thank you. So I'm going to start off by addressing some of the points that Judge Black brought up. In Department of Highway Safety and Motor Vehicles versus James Rose, the citation is 105 Southern 3rd 22, a second district court case in 2012. The circuit court correctly cited in its order that it was not permitted to reweigh evidence, and then went through the analysis of why it granted the petition. This court in James Rose said, even though granted second tier certiorari because the circuit court applied the incorrect law. And it came to the conclusion that the circuit court in its appellate capacity in first tier certiorari applied the incorrect law because even though it cited the proper standard through its analysis, it clearly reweighed evidence. And by reweighing evidence, it didn't apply the correct law. Just because the circuit court correctly cites to Dobrin for reasonable suspicion, because Dobrin does apply to reasonable suspicion cases. If the circuit court misanalyzed or misunderstood Dobrin in the way that it applied it, it didn't apply the correct law. Dobrin and Davidson have to be applied in the same fashion because they both stand for the proposition that if it's a non-traffic infraction stop, a reasonable suspicion stop, there's got to be some indication from the stopping officer that he or she believed this was a traffic stop based upon the atypical driving pattern leading them to believe that the driver is ill-tired or impaired, or that they need to do some sort of welfare check. And contrary to the point that Ms. Jones makes, She continuously argues today as well as in the past that all you need objectively is an atypical driving pattern. If she was correct, then this court's decision in Crooks is wrong, because they found that the traffic stop was invalid. In Crooks, there was absolutely atypical driving, but there's no suggestion of that Crooks may have been ill-tired or impaired. So it didn't, even though objectively there was atypical driving, it didn't justify a traffic stop. She's absolutely incorrect. You have to, if the court is addressing a reasonable suspicion stop, there must be in the record some expression that the purpose of the stop was believing that the driver is ill-tired or impaired. And so
in that case, the citation of the case of the second tier cert, what was the citation that you read?
that's Department of Highway Safety and Motor Vehicles versus James Rose, 105 Southern 3rd, 22, 2012. The second DCA, even though the circuit court articulated the right standard, came to the conclusion that they reweighed evidence, and as such, it's the application of the incorrect law. So in terms of addressing Judge Black, when the circuit court, even if it cites the correct law, doesn't apply the correct law, that's the application of the incorrect law, and that justifies second tier. So with all due respect, I believe that when the court didn't properly apply Dobrin, the court doesn't even discuss Davidson. I mean, the circuit court, even though Davidson is all over my pleadings, the circuit court just ignored Davidson and went with a Bailey case, which was pre-Davidson, and didn't include any discussion about that analysis. And then it cites to a circuit court decision from the Third Circuit, the Patel case. So it didn't even the circuit court, with all due respect to the judge, and I have all the respect in the world for him, he misanalyzed, and because of that misanalysis, he didn't correctly understand how Dobrin should be applied. So even though he cited to it, he applied the incorrect law, and by applying the incorrect law, we're entitled to second tier. That, by definition, justifies a miscarriage of justice when the circuit court applies the incorrect law. For those reasons, we ask that you grant the petition.
Okay, thank you both very much.
Thank you, Mr. Isaac.
Thank you, Your Honor.